The views and opinions expressed in this podcast are simply that, opinions. All are presumed innocent until proven otherwise in a court of law. Sensitive topics are discussed. Discretion is advised.
January 29th, 2022, Karen drives drunk. She reverses her SUV. She knocks JJ down. She leaves him to die in the cold. Rather than seeking to help or calling 911, she returns to JJ's home. Karen knows that the O'Keefe family is also vulnerable, grieving another tragedy in their family.
Karen Reed's civil suit rolls on with a new lawyer joining the O'Keefe team. Who is this high-profile wrongful death specialist? And a history of hospitalizations. The defense begins its case in the Bionca Ellis trial. We're going inside the mind of an alleged murderer. Plus, we're looking ahead to Donna Adelson sentencing. What can we expect on Monday of the now convicted matriarch mastermind? Also, this hour, Daisy Link's murder trial and what is not being brought into the courtroom that has everybody talking. It's all next right here on Opening Statements. And good Friday morning to you. I'm Ted Rowlands, filling in for Julie Grant on this Friday morning. So happy to have you along with us. Busy hour ahead. We're going to talk a bit about B.B. Fell. This is this new attorney that has been brought into the Karen Reed saga, hired by the O'Keefe family. This thing doesn't seem to be going away. Both sides building up. Alan Jackson is still involved for Karen Reed. Now you have B.B. Fell, a California attorney who has won some huge judgments. She'll be joining the O'Keefes. We're also going to talk about Daisy Link, that case. And the thing that is not coming out at trial is very interesting. Jury won't hear about it, but we'll talk about it because there are no rules here. It's opening statements. Before we get to anything, though, we do what we always do. We start off with the Daily Docket.
We jury find by a vote of 8-4 that Jose Soto Escalari should be sentenced to death for the murder of Tanya Wise.
Here is a look at some of the cases we're following today on Court TV in Florida. Convicted killer Jose Soto Escalari. We'll find out if he is getting the death penalty or not. The final phase of his sentencing begins 1:30 Eastern Time. Also in Florida, the state's case resumes in the 10:30. It's about 10:30 a.m. this morning in the toxic relationship murder trial. This is the Daisy Link case. We're going to talk about that coming up this hour. In Ohio, the defense continues its case this morning in the toddler stabbed murder trial for defendant Bionca Ellis. And that's where we're going to start this morning. Bionca Ellis, what was she thinking? What was this woman doing when she allegedly stabbed a 3-year-old? I mean, she stabbed a 3-year-old. That's not allegedly. She admits it. The defense admits it. And we saw on video that she went, grabbed a knife, and stabbed a 3-year-old boy and killed him. The defense's first witness, the defense case started yesterday, was a forensic psychiatrist, Dr. Megan Testa. She said that Ellis has schizophrenia, was hospitalized many times for refusing medication, and showed bizarre responses during her evaluation.
When I saw her in September, in August, for the September report, she did have a response. Her response, in part, was bizarre. She asked me about Jesus Christ and where he was crucified, and she made some other bizarre statements about Matthew and Jesus and taxes. She noted that Miss Ellis was seen sitting on the floor in her jail cell with no clothes on whatsoever. She was fixated on an investigation. She was eating her food with her hands instead of the silverware. She was making illogical statements, talking about dinosaurs.
Did she refuse or did she comply with taking medication?
She refused medications. So she refused medications in the jail. That continued until she got to North Coast. She refused medications at North Coast. She told me she would not take any medications prescribed to her by her treating psychiatrist. The reason was she said she didn't need it. She also had some delusions about the pharmaceutical industry, and she believed that her disorder could be treated with bananas, riboflavin, and apples.
Now, before the state's case ended on Thursday, the jury saw surveillance timeline, basically, of Ellis the day of the attack. Prosecution is depicting her as a very frustrated person that got a knife here at the thrift store and then acted out. She acknowledges the murder, and basically the defense is, okay, well, she was insane, and you heard a bit of the defense case there. So the question is, what was the alleged murderer thinking? Let's bring in criminologist, author, professor at St. Thomas University, Dr. Debbie Goodman, criminal defense attorneys Joe Tamburino and David Bruno. Good morning to you all. Dr. Goodman, you heard a bit of the defense expert that took the stand at the beginning of the case, and it does paint a picture of a disturbed person. What's your take?
Thank you. Good morning, Ted. My take is this is a vicious, vile, evil killer. I do not think she's insane. When people use knives, Ted, which, by the way, are used in 20% of homicides in this country, and it happens to be the #1 weapon among women who kill, it's a very purposeful, intentional crime. Why? Because the defendant and the victim are in very close proximity. So I think also what's critical here is the selectivity of the victim. This defendant picked probably our most vulnerable member of society, a child. So I do not think she's insane. I think she knew what she was doing. She knew what she was doing is wrong. Does she have a mental health issue? Probably, as do most killers in our country.
Joe Tamburino, what's the legal threshold that the defense needs to get over to convince a jury that she's not guilty by reason of insanity?
Well, hi, Ted, and thanks for having me on. What they have to do is show that under Ohio law that she had a mental disease or defect which caused her not to realize what she was doing, basically, not to know the nature of her acts. And I agree with Dr. Debbie. I think this person clearly is a schizophrenic. However, being a schizophrenic doesn't mean you are legally insane. You would have to rise to the level that you did not know what you were doing. That's going to be a problem in this case. Why? Because of some of the evidence, such as that gentleman who testified for the state who said he talked to Ms. Ellis right after this and said, hey, do you realize you stabbed this kid? And she's like, yeah, oh, well, you know, what can you do? And then the other evidence about possibly her trying to hide the knife afterwards. So that means that this person is thinking about what happened. So I think the defense has some good arguments and their experts are decent. I just don't know in the end if they're going to be able to pull that off.
You're talking about Travis Bush, basically the eyewitness there. Let's listen to that recount after witnessing him in this parking lot at the grocery store. Was in horror, seeing that this little boy had been stabbed. Here is basically his rendition of the reaction of the defendant.
I said, do you know you stabbed that kid?
And what were your observations of her at that time? Did she look at you?
Yes.
Did she respond to you?
Yes.
What did she say to you?
With the shrug and mouthing so.
So what? She says. David Bruno, she's naked in her jail cell talking about Jesus, taxes, and riboflavin. She sounds nuts to me. Why do we think she's not?
Yeah, that's exactly where I want to go, actually, because as a forensic psychiatrist, you have to look at the data. You have to look at before and the medical records. Obviously, there's probably some history there. And then you look at after. But especially on after, when somebody's charged with a crime like this, you really have to critically look at that to determine if that's being faked, if it's malingering. And as forensic psychiatrists, they know to look out for this. And the DSM gives guidance on malingering and the factors and things like that. So I would imagine that the state's expert's going to come up and basically say she's in trouble. She's charged with a crime. She's killed a 3-year-old. And certainly those actions, those verbal communications, those things that she's doing in the jail cell may clearly be explained by the prosecutor as malingering.
Dr. Debbie, the state is saying, listen, this was a frustrated person that acted out, and the part of the state's case is this video, this progression, showing her going to the thrift store to look around, pick out a knife. I mean, you see her look at this one and then go get another one. And at that point, the intent is formed. She is angry at her life and angry at something, and now she's just going to make someone pay, doesn't know who yet, till she gets to the grocery store. And then the cart of the mom sort of bumps her a bit or just cuts her off, and boom, now I have my victim. Do you buy that scenario in terms of the state's argument that this is a person that knew exactly what she was doing? She was acting out because of frustration.
Yes, Ted, I buy the argument. I agree with it. Again, I think when we look at this particular killer, she selects her weapon, as again, most murderers do. Weapons of choice are generally the gun, the knife, ligature for strangulation. And she purposefully selected a child, knowing that there would be no fighting back, no pushback, as well as a mom who was, diverted in terms of her attention with the groceries, as is very understandable. So we know how quickly the demise happened. And there are other types of crime, Ted, as we know, involving knives, cutting, slicing, but these generally don't lead to fatalities. That's why they're classified as aggravated assault. But this stabbing with such force and just ferocity that this woman had instilled in little Julian to puncture his lung and leading to the loss of life within seconds, I think she is absolutely vicious, vile, pure evil, and deserves the highest penalty possible.
Here's Margot Wood, that's Julian's mother, talking about this horrific attack that took her son.
I moved, and she stabbed him in the side of his face. And then she stabbed me.
Take a minute. I'm going to ask a question.
Joe Tamburino, the awfulness of this crime in and of itself would lend one to think that anybody on a jury is going to have an issue with coming back with any sort of verdict that says not guilty on it, even not guilty by reason of insanity. For a layperson, you don't want this woman walking the streets is the bottom line. And when a little boy is murdered in a grocery store parking lot, jurors are human beings as well, and there's frustration and anger. I can only imagine what jurors are going through in terms of their emotions. Our viewers have them. Your thoughts on the strength of the case because of the crime, just the horrificness of the crime?
Very strong because of the horrificness. And what you're touching upon is the fact that by far, and I don't know the exact statistics, but by far, insanity defenses fail. Why? Because you just hit on it, Ted. Most people, even if they think somebody, well, yeah, maybe they were somewhat insane or whatever, you're right. They're not just going to give them a pass saying, hey, here you go. You're not guilty by reason of insanity. And many jurors, in some states they instruct on this, some states they don't know that a person after being found not guilty because of being insane will be civilly committed. But I think it's very difficult for jurors to simply say, we're going to put aside the hellacious act that this person did and just simply concentrate on their mental state. We ask them to do that, but I think it's really tough for them to pull off.
Yeah, absolutely. The defense case continues today. We'll have updates throughout the day here on Court TV. Coming up on opening statements, Karen Reed's civil lawsuit trending this morning as a new attorney joins the O'Keefe team. Plus, Mama Donna returning to the courthouse for sentencing, what we can expect from the matriarch mastermind.
We, the jury, find as follows as the count one of the indictment, first-degree murder. The defendant is guilty of first-degree murder. Mrs. Adelson, control yourself.
The Court TV podcast will return.
What say is the defendant at the bar
leaving the scene after accident resulting in death. The defendant not guilty or guilty? So say you, Mr. Foreman? So say you are?
The standard in the civil lawsuit is far different than the beyond a reasonable doubt standard applicable in the criminal case. So the hurdles that the O'Keefe family will have to overcome are lesser than the prosecution has in the criminal case.
And the second thing I want to say is no one has fought harder for justice for John O'Keefe than I have and my team. Thank you.
That was Karen Reed after she was acquitted of killing her boyfriend back in June. A new attorney is in the mix, though, in the wrongful death lawsuit. That could make a difference in the outcome here. The O'Keefe family filed the lawsuit naming Reed along with the 2 bars that the couple and their friends were drinking at before John O'Keefe's death. O'Keefe's family is now seeking to add California-based lawyer Bibi Fell to the mix. Here is a background on Bibi. Founded the San Diego Fell law firm, focuses on catastrophic injury, wrongful death cases. 2018, second largest personal injury verdict in California, over $100 million. She is good. She's good at what she does. The suit alleges that the same events as the criminal prosecutors alleged, basically that Reed was drunk, drove her SUV, hit John O'Keefe, left him to die in the snow. He suffered serious injuries and died, and she left. So we're asking, how will Bibi impact the O'Keefe versus Reed civil trial? Let's bring in to discuss retired FBI Special Agent Jennifer Coffindaffer and criminal defense attorneys Joe Tamburino and David Bruno are still with us. All right, Jennifer, what does this move the ball for the O'Keefe's lawsuit against Karen Reed?
Well, I think the best thing about Bibi is she brings all of this experience and particular expertise in this area of wrongful death, and that's what the O'Keefes needed. Listen, she has gotten so many suits settled and won huge verdicts in court, so she's a good litigator. Specifically, I note a $5 million judgment that was rendered after a child was hit on a bike. I think that those facts kind of closely mimic this. I look for Bibi to come in like a firestorm.
Joe Tamburino, this is a building up. You've got Alan Jackson hanging on with Karen Reed on the civil case as well, helping that team out. Now you're seeing the O'Keefes also bolstering their forces, to Jennifer's point. And Bibi is a good litigator. It's not, she's not a civil attorney that's afraid to go into a courtroom. She will fight it all the way to the end with a jury, and it looks like that's where this thing's going.
Yes, and whoever the O'Keefes hire, they've got a really good chance of winning this case for 3 reasons. Number one is less burden of proof. They only have to prove preponderance that Ms. Reed killed Mr. O'Keefe. Preponderance means more likely than not. Number two, Ms. Reed will testify because in the civil case, she won the criminal. She doesn't have a right against, self-incrimination. So she could be called to testify at trial. She could be deposed. And number three, you're going to have less outside influences. I don't think in this civil process, you're going to have a lot of outside influences like, the Turtle Boy factor and everybody else who was outside of the courthouse. I just don't see that happening in the civil case. So overall, whoever the O'Keefes hire, they've got a really good shot at winning the civil case.
I don't know about that, Joe. I don't know that there's not going to be an army of people outside anywhere where Karen Reed is because, for whatever reason, people are just all in. David Bruno, your thoughts on the addition of Bibi to the O'Keefe team?
Yeah, I'm with Joe on this one. I think the plaintiffs are in a strong position just because of the difference of the burden of proof. The best example of that is the OJ case, right? He was acquitted on the criminal. He was found liable in the civil. And that's the difference in the burden of proof. For the plaintiffs in the case in the O'Keefe family, they really need someone to manage the circus. I mean, this has been a circus, to say the least, honestly, with Turtle Boy and then the allegations about law enforcement misconduct and all the things. So I think what Bibi brings, at least to the team, is the ability to sort of manage the chaos, because that's exactly what's happening here. It happened in the criminal case. We could expect it again in the civil case. And I think that it's good that she's added, but I think that they're already in a very good position in a different venue.
Reed's team may have picked up a small victory after the judge in this case dismissed a claim of emotional distress from John O'Keefe's niece. Here's some portion of that argument from the plaintiff's attorney.
Karen Reed plots, she fabricates a conspiracy, she launches a public campaign of disinformation, and she involves a blogger named Turtle Boy. She leaks not for public information through him. She pits her followers against the O'Keefe family, and all the while, Karen knows that the O'Keefe family is also vulnerable, grieving another tragedy in their family. The O'Keefes and Kaylee suffer severe emotional distress. It's more than anguish and more than grief, and it is not overlapping with the wrongful death statute.
Although the judge agreed to dismiss that claim, he did rule that other claims of reckless or intentional infliction of emotional distress can stand, pointing to Reed's narrative. The parties are due back in court in November. No trial date's been set. So we're asking which side has an advantage so far. Jennifer, it is really early in the civil process. When you factor in the Reed team's threat, if you will, that they are going to be launching lawsuits against Proctor et al., and they want them to be enveloped into this case. The judge has to decide on that. I mean, the deadline for discovery isn't until December of next year. This is not going to trial anytime soon, but at this early juncture, this is the question, so let's answer it. Who does have an advantage at this point?
Well, the facts would tell you, based on this new burden of proof in the civil, as Joe has discussed and David discussed, it's so much lower. So for that reason alone, I believe the O'Keefes have the advantage. The facts absolutely support that he was hit by the car, that he was hit by Karen Reed, but the burden has to be met, and this one is much lower. So for that reason, they have the advantage at this point.
Joe? You agree?
Well, yeah, like I said before, I think they do have the advantage. And, you know, David mentioned about the OJ case, and that is the quintessential example of somebody winning in the criminal side, not guilty, but losing in the civil side. And what was a determining factor in that case? OJ had to testify, and he was horrible. And the same thing's going to happen here. Karen Reed will have to testify in the civil case. Now, if there's no trial, she'll still be deposed. She'll be under oath, and the plaintiff's attorneys are going to be grilling her left and right. And she's never gone through that before because she didn't testify at her criminal trials. So I still think the plaintiffs will have the upper hand in this.
Just because of the rules of the road, let's talk about if it goes to trial, as you say. Well, the judge sort of gave both sides a pep talk and said, you don't want this to go to trial, people. Take a listen.
The parties also have another way to do this case. They can do it by way of potential resolution. And I mean this sincerely when I say that being a judge for many years, you learn things. And what you learn is that oftentimes litigation is an inartful way to try to resolve parties' disputes. There's alternative dispute resolution, there's mediation, there's all kinds of other avenues that we advance to try to get people what they want, which is resolution of a case. The most important thing, it would seem to me, to any party to this case, is to resolve the uncertainty, right?
David, do you think there's a chance this thing does settle?
Yeah, see, that judge is doing what judges do. They're trying to get those cases out of their courtroom, and that judge knows exactly what he's getting into. I mean, the trial that we had in the criminal case, the two trials, now coming into the civil case, is going to take time. It's going to take court resources. It's going to take a lot for not only that court, but the community to go through another trial. And it's not just that judge. It's not this case. That's what judges do. Judges are trying to resolve, and then if there are disputable issues of fact or law, that's what trials are for. But that's the same thing going on in every single criminal and civil courtroom across the country, trying to resolve cases amicably.
Yeah, and Jennifer, I saw you shaking your head. This isn't going to end anywhere, right? Quickly.
Okay.
No.
Yeah, no way. There is no way. I mean, look at the fact that Alan Jackson is now coming on to bolster the civil side of things. They do not want to lose. They want a full-on 100% victory with this, so they are not going to acquiesce. So therefore, we're going to have a trial.
Okay, well, we'll be watching, that's for sure. Jennifer, thank you. Appreciate your time. Enjoy your weekend. Still to come, we're talking about now convicted Donna Adelson. Donna will be back in court Monday. We'll preview her sentencing next. Plus, a woman standing trial for the murder of her partner, but details about how she got pregnant behind bars has everybody talking.
Now, back to the Court TV podcast.
This morning, we are spotlighting the upcoming sentencing of convicted murder-for-hire mastermind Donna Adelson. She returns to the Leon County Courthouse in Tallahassee on Monday. Adelson faces a mandatory life sentence for first-degree murder, conspiracy to commit murder, and solicitation, all in the death of Dan Markel, her former son-in-law. Dan Markel was shot just outside of his home, in his garage, in his car, back in 2014 by two hired hitmen. The Florida State University law professor and father of two young boys would have turned 53 years old yesterday. Let's take a look back at the verdict.
We, the jury, find as follows as the count one of the indictment, first-degree murder. The defendant is guilty of first-degree murder. Mrs. Adelson, control yourself. Count two, we, the jury, find as follows as the count two of the indictment, conspiracy to commit first-degree murder. The defendant is guilty of conspiracy to commit first-degree murder. Count three, we, the jury, find as follows as the count three of the indictment, solicitation to commit first-degree murder. The defendant is guilty of solicitation to commit first-degree murder. And it is signed and dated by the foreperson.
All right, let's bring in special guest who knew Dan Markel, former state attorney for Palm Beach County, Florida. Dave Ehrenberg, now a lawyer in private practice. Dave, great to see you, sir. Happy Friday to you. Dave, Dan was going to turn 53 yesterday, and it's something like that, an anniversary of a birthday. It really brings home how young a man he was and how accomplished he was in his future. I mean, this is a guy that he was just a head above most other people that walk this earth in terms of his intelligence, his dedication to his family. Talk a bit, if you would, about him and your experiences with Dan Markel.
Ted, Danny went to Harvard undergraduate and Harvard Law School, and he took time off in the middle to do great things. He was out in the working world, writing papers and studying, and just was exactly as you described. He was someone who wanted to make a difference in the world. That's why instead of going to a big New York law firm, he moved to Tallahassee, a smallish town, worked as a university professor, and dedicated himself to the next generation, to teaching young people. And it was his dedication to his children, his sons, that led to his murder in a time when we should be encouraging fathers to be closer to their kids, to be fathers. He was murdered for doing just that.
Her reaction, What's your take on her? The always overly dramatic, shocked that this could have, in a million years, have happened to her. That she's still taking there's nothing there that is acknowledging anything, it seems. What's your take on this whole thing, how it got so out of hand, to the point where a grandma basically orchestrates the murder of her son-in-law so she can get those 2 kids?
This is what happens, Ted, when someone thinks they're above the law, they're entitled, they can get away with anything. I mean, her son had a license plate on his Ferrari that said Maestro, and he thought he was the maestro here. And finally, reality hit them hard. And I would say that those are crocodile tears that she's shedding, but I didn't see any tears at all. I didn't see any waterworks. So to me, that reaction was not one of sorrow, of sadness. That reaction to me was one of anger. She was lashing out at the jury. She comes from South Florida, from money, from prestige, from privilege, and she's there being judged by individuals who she thinks that are beneath her. I mean, you can see by her correspondence up to that point, she hated Tallahassee. She looked down upon the people of Tallahassee, and yet they're judging her and taking away her freedom. How dare they? That's what's going through her mind, in my view. And that's why those of us who have been following this case closely and we're friends with Danny have a bit of schadenfreude, because we think this was long in coming, well-deserved, and she can't get into prison soon enough.
Yeah, and Phil Markel said that in the Jewish tradition, you wish someone to live 120 years as a way to say, yeah, I hope you have a great life. He says, I hope you live 120 years in misery. And he and Ruth both got up and spoke after the conviction. Judge Everett let them do their victim impact statements because, of course, they live in Canada. We don't know if they'll be back on Monday or not. But here's a bit of Phil talking to Donna.
She has harmed forever the people she claims to have loved. In the Jewish custom, we have an expression to always wish others to live to 120 years of age. For Donna, I wish her to live to 120, alone in her jail cell. I wish that every day of her remaining days, she thinks about the harm she has caused to so many, especially those 2 boys she claims to have loved so much. For these reasons, Your Honor, I ask the court sentence Donna Adelson to the maximum possible sentence. And my only short question to Donna, was it worth it?
The Markels have been through so much. Is it over? Do you think that the prosecution team that's done such a fantastic job in all of the cases thus far, from the hitman to Katie McManus to Charlie, now Donna, is done? Or is Wendy possibly next? Maybe Harvey?
2 words: stay tuned. Those aren't my words, Ted. Those are the words from Georgia Kaplan, the prosecutor in this case. She also said that very thing before they made the arrest of Donna. So that to me tells me that Wendy is next. I predict that Wendy will be indicted by Thanksgiving. That's my prediction. I don't have any inside information, but if you watched the trial closely, which you did, you can see that Wendy was a featured player. And after the verdict, the jury foreperson came out and said that Wendy, who was the ex-wife here, deserved to be next. Now, she wasn't sure what the charge would be, but she thought Wendy was guilty. Remember, this wasn't a trial about Wendy. This was a trial about Donna. And if you have the jury foreperson come out and say, oh, yeah, the ex-wife was involved in it, that's not good for Wendy, because they haven't even shown half the evidence they have against Wendy. So I do think she's next. I think it strains your mind to believe that somehow the family, the mother, Donna, the brother, Charlie, all did this, all murdered Danny Markel and didn't let Wendy know. Not only does the evidence seem to show that Wendy knew, but there is evidence that Wendy was involved in some way. Whether that's enough to file charges, we'll know soon enough. But my money is on an indictment.
Okay. Dave Ehrenberg on the record. Thanksgiving probably before Wendy is next. We'll wait and see, but you're right. This case, unlike the other trials where there was some Wendy, but it was more Donna, this one was, there was a lot of Wendy from the prosecution standpoint, and it would seem that this would be the next step. If there is one, Dave Ehrenberg, as always, thank you for your time on this Friday. Enjoy your weekend. Still ahead, defendant Daisy Link got pregnant behind bars after she was convicted. Will she be convicted of murdering her boyfriend? We'll wait and see. But her trial's going on. How did she get pregnant? Well, if you haven't heard the story of what supposedly happened, it's something else.
This is the Court TV podcast.
Self-defense or murder? That is the question in the toxic relationship trial for Daisy Link. Prosecutors say the Florida woman allegedly murdered her boyfriend. Link says she was acting in self-defense. Scripps News Group Miami reporter Leanne Morejon has a look back at what happened in day one of this trial.
Daisy Link cringes at the sights and sounds from a sergeant's body-worn camera captured during the wee hours of June 25, 2022, when Homestead police responded to a call about a man bleeding out. The state says Link made that call herself moments after she fired the single shot that killed Pedro Jimenez, her on and off partner and father to two of her children.
In a fit of rage, she pulled out the gun, and the facts will show he had turned around and was running away in fear.
The state and defense both agree Link's relationship with Jimenez was tumultuous.
Arguments, anger, and even jealousy.
But the defense paints Jimenez as downright abusive. They say Link shot Jimenez during an argument in fear for her life.
The evidence will show this man was out of control. He was unhinged and he was dangerous. And she fired a shot to get him to go away.
A Homestead sergeant testified to Link's behavior at the scene, where she implied she didn't know what happened to the victim.
She was screaming. I believe at one point she stated she was asking him what happened.
Contrast that with what she's caught saying with the gun still in her hand.
A gun was located inside an areca palm.
Link made headlines for other reasons last year when she was impregnated by another inmate while behind bars. But jurors are not expected to hear those details during her murder trial.
Yes, but we want to talk about those details because well, you got to hear it. So the jury's not going to hear it. According to multiple reports, Daisy Link becomes pregnant while in jail from another inmate. All right, well, somehow they got together, you think? Well, no, this is what apparently happened. Reports say that the dad, who is also on trial for murder, sent his semen through the old air conditioning vent using string and saran wrap. She would later say this was a miracle, this conception. How would this evidence have tipped the scales if the jury was able to hear about it? Let's bring in Dr. Debbie Goodman, criminal defense attorney David Bruno. This is a lot to get your head around. You receive a package through the air conditioning unit, and you can do a lot of things with that. She apparently decided to do something with it. What's your take, Dr. Goodman, on why you would? What's your take on this?
Thank you. Ted and David, we've talked about so many cases and we think we've heard it all, seen it all, but wow, this one I've never heard of. And admittedly, I had to read this one twice. So, we just talk about the crime itself, and I don't think it's self-defense. I think it was, she's guilty of murder, perhaps the second degree. And secondarily, this issue about the becoming impregnated, my first thought is always, okay, some type of inappropriate liaison or relationship with an inmate and a prison staff member, a corrections officer, and that didn't happen. And then when we got the details of what did happen, it is quite astounding and quite alarming. So I am certain that as we're speaking about it, so are corrections administrators and command staff throughout the country at prisons and jails. And historically, we know about contraband, that it's drugs, it's weapons, it's money and phones. And I think this now has to be added to the list, and that would include bodily fluids.
David, if the jury's not going to hear about this, clearly, if the jury did know about it, would it help or hurt her?
Hurt her. I mean, it goes against credibility. It goes against, you know, the right to follow the rules. And that's what our criminal justice system is for, to keep it out. All right. In this state and in most states, there's a rule of evidence, 404B. Generally speaking, we don't want to bring in the bad character evidence, the other acts evidence, the things that have no bearing on the allegations in the courtroom. And this is a great example of that. It does not come in. It's not there to prove plan, purpose, identity, lack of mistake, motive, opportunity, none of those things that would be otherwise permissible reasons to bring in other acts. So she's lucky because it's prohibited in her criminal trial, and I don't think it's going well anyway. But if it was admitted in addition to the video and the statements that she made in her criminal trial, it wouldn't help her either.
Dr. Debbie, this relationship, everybody agreed, was very toxic between the victim in the case and the defendant. They would fight a lot. And the defense here is self-defense, that she was scared because he was in her face, and even though he was running away, she shot him. Is there a scenario in a toxic relationship where it seems to be a give and take? Both are at it. It's not a battered partner syndrome scenario. Is there an opening for her in terms of a defense that I was scared for my life, even though it's well documented they fought a lot?
Not based on the facts of this case. That certainly in other circumstances, yes. But again, Mr. Jimenez was running away. He's the father of her children. Her conduct displayed on the body cam, the testimony in terms of what she said, just this lack of remorse and carefree attitude, and, oh, you'll be okay, as if he got a little, he stubbed his toe or something. So I don't see it at all. I think she is going to be found guilty of a second-degree murder.
Yeah, when she's walking away, gun in hand, you'll be all right, I didn't hit an artery. I mean, and just so callous, and she's not displaying this, at all, and the jury has seen that video. So one would tend to agree with you, Dr. Debbie. David, Dr. Debbie, thank you very much for your time on this Friday. Enjoy your weekend.
That's all for this episode of Opening Statements, my friends. I'm your host, Julie Grant, and it's been great being with you. On this show, I am calling out any pants on fire moments in our big trials and true crime stories, and I want you to come along with me. Opening Statements is live every weekday morning at 8 a.m. Eastern on Court TV. Thank you for downloading this episode. Please subscribe, leave a review, and share it with your friends. You can watch past shows anytime you like on CourtTV.com.